gentleman from Tennessee, who I owe a recognition to, is now recognized.
Thank you, Mr. Chairman. First of all, I'd like to remind members that the EPA, which is the law most under attack for all these opprobrious regulations, was President Richard Nixon's #1 legislative accomplishment. Secondly, I'd like to suggest that when I look at a map here of the states that recognize Tennessee's concealed carry law by reciprocity, most states already do it, but the states decided. They didn't have the federal government tell them to. The big state that doesn't stands out, big old pink state, is Texas. I don't know what your problem is. We brought some guns down there in the 1840s and helped you all out a lot. Y'all should remember that. But now, yes, sir.
I think it was 1836, but...
Well, it was within the margin of error. Tennessee requires a person to be 21 years of age to get a gun permit. Some states don't. You just have to be 18. Does it make sense to say to the states that require you to be 21 that you can have 18 and 19 and 20-year-olds now coming into your state with guns? I submit not. My friends on the other end of the side of the aisle are great supporters of states' rights until this happens. It's as if somebody's holding a gun to your head. I don't understand it. I'd yield back the remainder of my time.
Thank you, Mr. Cohen. The gentleman from South Carolina, Mr. Gowdy.
I thank the chairman, and the gentleman from Tennessee raised a very good point. I would be curious whether or not he agreed with me that there's a constitutional right to travel.
I don't know that there is. I think there's a constitutional right to, there's speech, there's redress your grievances, petition your government, freedom of religion.
You do not think the Constitution, within the penumbra of any...
It probably does in the penumbra. I just can't place a specific case or a specific...
Do you think inherent within the Constitution is a constitutional right to defend yourself?
I guess there is. I don't know if it's in the Constitution. You have a right to liberty in the pursuit of happiness, and maybe defending yourself allows you to have happiness. Liberty is maybe there. Of course, that's a Declaration of Independence. I don't want to get like Governor Perry. I'm sorry.
Well, the gentleman from Tennessee is an extremely accomplished, highly decorated attorney who I have great respect for his legal acumen, but I guarantee you that no one on the other side of the aisle would allow there to be any restrictions whatsoever on the First Amendment. You would go nuts if we argue that states' rights allowed South Carolina to somehow impact the First Amendment. Or the fourth, that we were going to have all these different search and seizure requirements based on the 50 states. Or the fifth, that Miranda was going to be subject to what South Carolina wanted, or Utah wanted, or Nevada wanted. Or the eighth with cruel and unusual punishment.
Would the gentleman yield?
I am just curious why the Second Amendment is afforded so little.
Would the gentleman yield?
If what you're saying is that the Second Amendment...
The gentleman from South Carolina has the time.
Would the gentleman yield?
Sure.
First of all, I don't think anybody would say that the First Amendment, the Fourth Amendment, or any of these other amendments are absolutes. There are limits on all rights, as the Supreme Court has said.
What restrictions would you allow the state of South Carolina to put on the First Amendment?
Well, the state of South Carolina can certainly have libel laws. The state of South Carolina...
Not that Trump, New York versus New York Times.
No, of course not. The Supreme Court, in our system of jurisprudence, despite what certain former members from Indiana thought,
can we require a test before you become a blogger? Can we require a test before you become a blogger to make sure that you would be a responsible?
If the gentleman would yield, let me answer the question. No, but the Supreme Court has delineated the legality of various limitations. The classic one, of course, is Justice Holmes' formulation: you can't cry wolf. You can't cry fire in a crowded theater. Unless, of course, the state says, yes, you can. But if the state says you can't, the First Amendment doesn't give you the right to do so.
My point is Heller said the right to keep and bear arms is a fundamental constitutional right that should be afforded the exact same amount of respect as all the other rights in the Bill of Rights. And we would never allow this I won't use the word that comes to mind. I can't and judge motives. I was going to say charade, but I won't. We would never allow any other amendment to be subject to what we've been doing for the last 2
Well,
days.
if the gentleman would yield, no. We allow, that's not the case. We allow other amendments to be subject to reasonable limitations, and the courts obviously delineate how far you can go.
There's a national standard with respect to the Fourth Amendment. There's a national standard with respect to the Eighth Amendment.
But even,
There's a national standard with respect to the Fifth Amendment.
within those national standards, there is some leeway for states.
What
state
state can disregard Miranda?
You can't disregard Miranda,
Which state cannot give an attorney if you are facing a felony charge?
Say again?
Which state cannot afford you counsel if you are facing a felony charge?
There are certain things that states cannot do, obviously, but there are other things that states can do. States can have, for example, libel laws. How far you can go, the Supreme Court rules. States can have laws against, states have laws on searching vehicles, for instance, which the courts have declared do not violate. I disagree with some of those, but the courts have declared do not violate your Fourth Amendment rights. And the courts, frankly, have gone farther in giving the states...
can give more rights than are what afforded by the
that's not what we're talking
Amendment,
about.
but they can't give less rights.
No, but defining how far those rights go is what the courts do.
Well, I guarantee you, if this were a conversation about what limits to put on the First Amendment, you would be apoplectic. If we were going to require tests, if we were going to subject the First Amendment to the same scrutiny that we do the Second Amendment, there would be apoplexy on the other side of the aisle. And I am just curious why the Second Amendment is afforded so little deference.
Mr. Gowdy, would you yield?
I'd be delighted to yield to the gentleman.
The gentleman's time has expired. The gentleman has yielded an additional minute.
Yes, sir.
Thank you. Are you submitting that there should be a national right to carry law and that the state laws are violative? Because if you have state laws that limit who can have a gun, that they are in essence violations of the Second Amendment, because the Second Amendment says everybody should have a gun.
What I'm asking is why we have a national standard for every other amendment except the Second.
Well, we don't have necessarily...
Because I have been getting, some of it good-natured and some of it less than good-natured, lectures on states' rights. There are more defenders of states' rights on the other side of the aisle in the last 2 days than I have heard in my previous 7 months. The states' rights emanate from the Ninth and Tenth Amendment. The Ninth and Tenth Amendments come after the Second Amendment. So the notion that we're going to choose states' rights when we like it and ignore them when we don't, I just find that to be sophistry.
Well, that's what we're suggesting, is the sophistry is bipartisan.
Will the gentleman yield? Will the gentleman from Tennessee yield?
Sure, I'll yield. I don't...
I appreciate this exchange very much. It seems to make exactly the point I made yesterday that was so vehemently objected to. The question I asked yesterday of the amendment sponsor
was... The gentleman has yielded an additional minute.
Thank you, Mr. Chairman.
Well,
the gentleman from Tennessee,
the gentleman from South Carolina has the time.
I think the gentleman from Tennessee has the time.
Don't waste your time.
In any event, the question I asked was, if it's eligibility requirements today, then isn't it likely that where we're headed next is the suggestion that there should be no ability for states to impose their own regulations with respect to where the handguns can be carried and how it's actually implemented. The fact is, as I explained, in Florida now, there are all sorts of public places that are open that one can take a concealed handgun. In other states, no. I was told very clearly yesterday, no, it is acceptable for states to regulate those certain aspects, but as to eligibility, there should be a national standard. I think you're suggesting that this is merely a first step and that ultimately the goal is to eliminate any state regulation altogether.
I think you're giving me more credit than I deserve. What I am suggesting is simply this. There would be apoplexy if we required any kind of test for the exercise of any other right, and the Second Amendment is treated as a stepchild in constitutional jurisprudence, and I'm just curious why that is.
The gentleman's time has expired. Mr.